Hi, Mel Henshaw here again. You went in court videos, and we're doing another case study here. I've started to do those at the request of my friend who's doing the videos, and I said that's a good idea. And I came across one in reviewing some cases that you're going to love, called Oregon v. Mitchell. And I'm going to give an intro to this because it's important because of the way I've read this opinion and what I know about this justice. And this is where you can separate the wheat from the chaff. I'm willing to bet you the majority of law school professors don't know what I'm about to tell you about John Marshall Harlan and why he did this opinion. And that is that Harlan, if you don't know, was on the court from 1955 to 1970. It's an Eisenhower appointee. Don't ask how that happened. Um, and was a good, solid justice, and was for most of his terms on the court considered the court's leading expert on the subject of federalism. In other words, what's proper for the federal government to do and what's proper for the state governments to do. And only very rare areas are there any conflicts, although these days, after, NLRB versus Jones and Laughlin Steel, now the federal government thinks that taking a crap in a public funded bathroom, it affects interstate commerce. Harlan would be shocked if he knew that, if he was still around today. But that said, this is a peculiarly strong source for this opinion that I'm going to read you some excerpts from. And it came at a time when I think he realized, at the end of his career, and maybe before, actually, if any of you that have personal knowledge about Justice Harlan, I'd love to hear it, especially on this subject. Because I suspect this opinion, 106-page dissent in the case of Oregon v. Mitchell, and he mentions a case called Baker v. Carr quite a lot from 8 years earlier, where the Supreme Court decided, in effect, that the Voting Rights Act of 1964 applied to the states, despite the fact that it was enacted, quote unquote, pursuant to Section 5 of the non-existent 14th War Amendment. So with that background, and, given the fact that, maybe he hadn't found a case in the intervening 8 years, but this one came along, and he was probably well aware that he wasn't going to be around for the next term of the court, which he wasn't. He made this opinion. And another quick note before I get started with excerpts is that his grandfather, also Justice Harlan, he's best known for his solo dissent in the infamous case of Plessy v. Ferguson. And Justice Harlan here realized that his grandfather was wrong about that too. And for a brief description of why, I always use a quote from C.S. Lewis, I believe it. No, T.S. Eliot, where he said that the last temptation is the greatest treason, to do the right thing for the wrong reason. And that's what they're doing with all this 14th Amendment case law crap. It doesn't matter what you're trying to do and how good a result it's going to lead to. If you violate the Constitution in order to achieve the goal, that throws the doors wide open the next time, and it doesn't admit of any limits. So that said, this Oregon v. Mitchell, I'm going to read some highlighted excerpts. And by the way, this document will be available complimentary to anybody that makes a request for information from my constitutional defense document packets. Send me an email at youwinnincourt@gmail.com, and I'll get you this highlighted version of this and some other bonus documents that come along with requests as well. But this is a really good case to know about. And Harlan starts out saying from the standpoint of this court's decisions during an era of judicial constitutional revision in the field of suffrage. That's also known as judicial activism, something the court's not supposed to do. They don't make law there. They decide what's constitutional and what's not. That's their job. Marbury v. Madison, for crying out loud. Hey, it goes on, ushered in 8 years ago by Baker v. Carr. I would find it difficult not to sustain all three aspects of the Voting Rights Act Amendment of 1970. From the standpoint of the bedrock constitutional structure of this nation, these cases bring us to a crossroad that is marked with a formidable stop sign. That sign compels us to pause before we allow these decisions to carry us to the point of sanctioning Congress's decision to alter state-determined voter qualifications by simple legislation, and to consider whether the sound doctrine does not in truth require us to hold that one or more of the changes which Congress has thus sought to make can be accomplished only by constitutional amendment. And he's 100% right about that. And as those of you that follow my videos know damn well that I have a brief on the 14th Amendment that says it's unconstitutional because the ratification, quote unquote, violated all 6 articles of the Constitution. How come that has never been before the 905 in 150 years? Oh, get me started on that. Hey, goes on. Let's see here. Well, they talk about the various tests. It says Idaho will have to permit voting by citizens of other states formerly domiciled in Idaho who immigrated too recently to register in their new homes, and it must permit absentee registration and voting by persons who have lived in Idaho for less than 6 months, in plain opposition to Idaho law at the time. Okay, it goes on. For reasons to follow, I'm of the opinion that the 14th Amendment was never intended to restrict the authority of states to allocate their political power as they see fit, and therefore it does not authorize Congress to set voter qualifications in either state or federal elections. I find no other source of congressional power to lower the voting age as fixed by state laws, or to alter state laws on residency, registration, and absentee voting with respect to other state or federal elections. Okay, it goes on. Believing this view to be undoubtedly sound, I turn to the circumstances in which the 14th Amendment was adopted for the enlightenment on the intended reach of its provisions. And by the way, this dissenting opinion is 106 pages. It is a tour de force on the history of the Reconstruction times in the United States immediately after the end of the war between the states. If I had read any of this in 10th grade civics, my life would have been different over a half a century ago. None of it's there, and probably none of you listeners have a clue either. They didn't bother to tell you any of this stuff because they don't want you to know that you have rights and how to defend them. That's what I think Harlan was doing here at long last. Goes on. This, for me, necessary undertaking, this opinion, has unavoidably led to an opinion of more than ordinary length, and trust me, 106 pages is well more than that. Except for those who are willing to close their eyes to constitutional history in making constitutional interpretations, or who read such history with a preconceived determination to attain a particular constitutional goal. And that's what all of these black-robed bastards do in office today, with very rare exceptions. Predetermined outcome. Their opinion, not our proof. That's what has to change. Goes on. All papers relating to the representation of southern states were to be referred to the Committee of 15 without debate. This is pursuant to the enactment of this law that's being challenged. The result, which many had not foreseen, except for Roscoe Conkling, was to assert congressional control over Reconstruction and at the same time put congressional power in the hands of a largely radical Republican secret committee. That's not how we do business in Congress. It wasn't then, it's not now. Another major objection to all this BS that's got us so. I mean, and Harlan says it right out. Says the House, although somewhat bulky, approved the measure after lengthy debate. The Senate proved more intractable. An odd combination of Democrats, moderate Republicans, and extreme radicals combined to defeat the measure, with the radicals, basing their opinion largely on the fear that the proviso would be read to authorize racial voter qualifications and thus prevent Congress from enfranchising the freedmen under powers assertedly granted by other clauses of the Constitution. Goes on. It was reported by Congressman Bingham, who later opposed the Civil Rights Bill because he believed it unconstitutional. The amendment immediately ran into serious opposition in the House, and the subject was dropped. Okay, it goes on. The Reconstruction Committee had been unable to produce anything which could even get through Congress, much less obtain the adherence of 3/4 of the states. The radicals committed to Negro suffrage were confronted with the widespread public opposition to this goal, and not just in the South, it should be noted, and the necessity for a Reconstruction plan that could do service as a party platform for the elections that fall. Goes on. Let me pick up the start of the sentence here. The point of departure for considering for purposes in effect of the 14th Amendment with respect to suffrage should be, I think, the pre-existing provisions of the Constitution. Article 1, Section 2 provided in determining number of representatives in which the state was entitled, only 3/5 of the slave population should be counted. Section also provided qualifications for voters for such representatives should be the same as those established by the states for electors of the most numerous branch of their respective legislatures. Okay, it goes on. In a series of proclamations in the summer of 1865, President Andrew Johnson, our greatest president, and yet all I heard about him in school, and all you probably heard, was he was the first president to be impeached. They never told us why. They probably never mentioned it to you either. What he was impeached for was telling the truth. A strikingly odd habit for a politician to be engaged in. But he saw immediately what was happening and why, and was trying to stop it. Gets impeached for it. Okay, at the close of the war, there were 4 million freed slaves in the South, none of whom were permitted to vote. The white population of the Confederacy had been overwhelmingly sympathetic with the rebellion. Since there was only a comparative handful of persons in these states who were neither former slaves nor Confederate sympathizers, the place where the political power should be lodged was a most vexing question. In a series of proclamations in the summer of '65, Johnson had laid the groundwork for the states to be controlled by the white population which had held power before the war, eliminating only the leading rebels and those unwilling to sign a loyalty oath. The radicals, on the other hand, were ardently in favor of Negro suffrage as essential to prevent resurgent rebellion, requisite to protect the freedmen, and necessary to ensure the continued radical control of the government. That's the real reason for all this. For those of you who don't know, Lincoln was the first Republican president. The party was only founded in 1854 in Wisconsin. And they would have had a serious problem in the election. And if that had things gone well and Andrew Johnson not been impeached and more people paid attention and listened to him, he might have won re-election had he been renominated by the Republican Party. And by the way, he was actually a Democrat and was put on the party in the election of 1864 in an attempt to gain more votes from the South. That's how he happened to ascend to the presidency. And he was known at the time colloquially, by the way, as his accidency. But that said, what he was trying to do was the right thing, and you very rarely see a politician that wants to do that. And in this situation, it was critical, and he paid the full price for it. But that's what the whole business was about. You know, they didn't care. All they wanted to do was keep control of Congress, however they had to do it. And another note here for those of you that are unaware, the Supreme Court ruled contemporaneously in Texas v. White. I think the citation there is 6 Vol 300. I could be wrong about that, but contemporaneously, the states were never out of the Union. How is it that the 38th and 39th Congresses managed to keep the southern states from being represented, if that's true? And if they did that unlawfully, doesn't that mean that those Congresses didn't have a quorum to do business, let alone racial representation, to pass any laws whatsoever? It damn well does. And the South wasn't represented. And by the way, at that time, the Senate was appointed, senators were appointed by the legislatures in the several states. And that would have been done in that manner and should have been. And everybody showed up for the 39th Congress, the ones that had been elected and the senators who had been appointed, and they were summarily rebuffed without even so much as a hearing. You know, by that damn Speaker of the House, I'll think of his name in a minute. I want to say Thaddeus Stevens, but that's wrong. It's not him. But the Speaker of the House, and they were not even allowed a hearing, and the clerk of court motioned them just to leave the premises, and they did. And therefore, that Congress was over before it began because of the lack of representation of the southern states. There was none there. And yet they did all this crap in that time period to not only keep themselves in power, but to do the bidding of their corporate masters in the environs of 120 Broadway, New York. That's the real intent there, to make all kinds of money off of this, which they did. And I mean, you can't imagine. In fact, further on, as you get this document, you'll see in another document I'm going to have that one of the big arguments that upset a lot of people at the time was the cost of all these reconstruction programs and the maintenance of, in effect, war measures. And it amounted at the time, and remember, this is 1866, it amounted at this time to close to $250 million. Then, what would that be now? We're in the trillions if we're using today's quote-unquote dollars. And people were visibly upset. And by the way, one of the key provisions in the Civil Rights Act and the Freedmen's Bureau was that these agencies were to be protected by the federal military. What does that tell you about the jurisdiction of the courts that are reviewing these acts of Congress? They're not judicial courts, they're federal military tribunals. Exactly the point I've been making, without opposition, and here's why: there's no way you can oppose it. It is what it is. So if that's the case, and we have military tribunals, yet they exist within the borders of what should be a state admitted into this union, clearly and unambiguously we have no states. Simple as that. It was true in 1867. It still is today, 150 years later. It's time for it to end already. And we have it within our power to do it. That's the whole point of my work, is to attempt to do it myself in the time remaining that I have left, and at a considerable cost, by the way. This is my 14th year all in. Can't even apply for a job anywhere, let alone go to work and use my property in the form of my time and labor, at least the way they see it. So I've done that willingly. The sacrifice has risen close to 7 figures to the left of the decimal point using their undefined dollars. And I've been pleased to do that. That's what I was put here to do. If I had known this 50 years ago, who knows what changes might have been made a hell of a lot sooner. But I'm one of the people that can do it, and you get my materials and study my documents. And as I said, send me an email at uwinnincourt@gmail.com to learn how to get a hold of these documents. The best purchase you'll ever make, and about 95% less than what you would have paid an attorney. And I do a hell of a lot better work than they do, trust me. And study and teach your children so they can stay out of the system without ever have gotten into it. That's even better. It makes it harder for them to deal with when they get up there in front of the judge. And like what I did in Columbia, South Carolina, in my felony case there, and the judge read the charge, practicing all without a license, and I broke out in that and said, "Gee, Judge, I don't practice the law. I get it right the first time." Shut him up in 20 seconds. DA didn't say 2 words to me the entire 5 months I was there. They couldn't intimidate me, and they knew it. And that's what you will learn by acquiring my documents. You'll get that sense of confidence and self-esteem. The last thing these bastards want you to discover And their mandatory public quote-unquote education system is set up to be sure you never do. That's the whole point of it. That you never know that you have rights, you never know the history of this nation or what to do here. So that said, thanks for listening. Be sure to like my videos, tell your friends, subscribe, and I'll be glad to send you materials. Just send me a request and we'll get it to you. Thank you.